Well, I don't know exactly the order. You just mentioned about where to start, and I think the place to start is probably just go ahead and start with that Paddleford information that I just sent to you. And what most people assume is that they somehow created the U.S. when they did not. They don't have anything to do with it. It's not about them, and that's the reason we're going to start with the Paddleford case. You know, this is what I heard back in 1999 from Albert when he said the Constitution wasn't written for you, you're not signatory to it, and you're not of the posterity. Now, I already knew that because in language procedure, I knew the P was capitalized in the preamble. There was a language procedure that was known to the founders back then called a capital. When you capitalize the first letter of a word, you change its meaning, which is why they capitalized the word people of the United States, and it's exactly why they capitalized the word posterity. And when you look at the preamble and you understand contract language, the entity they formed was the people of the United States, which established the Constitution for the United States of America. It was one group establishing something for another group. Now, if one group is establishing for another group, that means they are in the superior position. So those that were the people of the United States were establishing a constitution for the United States of America. They weren't doing it because they were nice. These were the commandments of how they were going to run the charters and the government. We'll get into that about how they were going to manage the bankruptcy and pay back the $18 million that were borrowed from France by the United States of America, and what provisions had to be put in place to guarantee to the international community that that debt was going to be paid. Now, people arrogantly assume that they're smarter today than they were 200 years ago or 250 years ago. That in itself is a break in the thinking, since they will say that the public school system dumbs everyone down. Well, if it dumbs everyone down, then obviously we were included in the everyone. Paddleford case was specifically about a taxation case in 1854. The mayor and city alderman of Savannah, Georgia, was imposing inspection taxes and fees on Paddleford that they protested. Paddleford made an issue out of it, took it into the Supreme Court of Georgia, and this is part of the decision. The decision itself is probably 80 pages. The meat of the decision is all I really cared about. Supposing this not to be taxed for inspection purposes, has Congress consented to it being laid? It is certain that Congress has not expressly consented, but is express consent necessary? There is nothing in the Constitution which says so. There is nothing in the practice of men or in the municipal law of men or in the practice of nations or in the law of nations that says so. Silence gives consent is the rule of business life. A tender of bills is as good as one coin unless the bills are objected to. To stand by in silence and see another sell your property binds you to the contract. These are the mere instances of the use of this maxim in the municipal law. In the law of nations, it's equally potent. Silent acquiescence in the breach of a treaty binds an entire nation. The breach of a treaty can be done by the head, or it can be done by someone underneath the head, but it only has to be done by one. I'm on page 35 at the top. The center of that paragraph, we're talking about how the law of nations, the municipal law, apply when it comes to silent acquiescence, because the ancient maxim of law is silence gives rise to fraud or it gives rise to total agreement. Now, just because somebody's silent to you, you may not have standing to worry about whether or not they're silent to you. This stuff works real well in corporate dealings and contract dealings here in the U.S. among people and among corporations. It doesn't work well against the government because people are not sovereign above the government. The government is sovereign above them as United States citizens and as state citizens and as nationals and as aliens and as residents. And if you don't have political power, you have civil rights. And we'll show that in a minute about it, how civil rights are granted and how they can be taken away. Now, the principle at the bottom of these propositions is this: the states have no power. See, here we're going to go into state sovereignty, which there's this illusion that people have that being a state citizen makes them sovereign, when the word citizen itself means subject. In addition to that, they were not signatory to any of the compacts that created those states, and they're not the posterity of any of the parties that created those states. And the states themselves are not sovereign. Now, the principle at the bottom of these propositions is the states have no power, by the exercise of which they can defeat all ends of government, the general government or any of those ends. But the state, by the exercise of the taxing power, can take from their inhabitants every cent the inhabitants can spare, and the state can live. See, that tells you about state subjects right there, or state citizens. The state can take everything they got. And they've confirmed this in court decisions, even up in 1995 with the Emsminger case, where they said that the United States of America surrendered all right, title, and interest to the United States. That means all these people running around claiming themselves to be Americans have no right, no title, and no interest. Well, if you have no right, no title, no interest, then you have no standing to state a claim for which relief can be granted, ever. Does that make sense to you, Ray? Right. And the people that think they have some kind of say-so and that have no say-so, the system's going to do what it's doing because it's doing it for the posterity of those who created that system. Okay? According to the principle of this decision, therefore, the states have no power to lay any tax on their inhabitants, and if they have the power to tax, it follows that they have no power to enable them to keep up their state governments, and without state governments, they have no power to keep themselves alive as states. The principle comes to this, that the states, in making the Constitution, intended to give up the power of self-preservation, which we would also call self-determination. All right, I'm going to switch over to the next page. At least I think I am. Yeah, page 36. This was in a different page on this decision with Paddleford, but it gets into some things like we talked about earlier. The people of the states who made the Constitution considered themselves as the sovereign and the government as the subject. They were the principal, their agent. That this is true, none will dispute. And this is the commentary from this book where it says, we all know that it was not us people who made the Constitution, but the select few as stated by the court at page 520, wherein they said, but indeed no private person has a right to complain by suit in court on the grounds of a breach of the Constitution. The Constitution, it is true, is a compact, but he is not a party to it. Okay? The states are parties to it, and they can complain. If they want to complain on your behalf, then they're entitled to a redress. Or they can choose to waive their right to complain on your behalf. And the reason I say your behalf is because Schultz and we the people keep going to the Supreme Court, and they keep telling them, hey, we don't have to listen to anything you got to say. Well, right here it is. You don't have a right to redress. Because why? You should have gone to the state first, and then they chose to take up your cause. Then they can bring it to us, the federal government. Or they can waive their right to take up your cause. Well, their cause is whatever they think about the taxation with the IRS and Title 26 and 16th Amendment. And people say, well, the 16th Amendment was never ratified. Ray, let's just go back to silent acquiescence. Do you think the states have already agreed to the 16th Amendment according to the doctrine of silent acquiescence? There's nothing to ratify. Now, in addition to that, I'm going to go ahead and get out of these 2 pages here. There's not even a need to spend a lot of time on it. People don't have a right to redress. The states have a right to redress, so you have to go to the state to complain. Then they get to choose whether or not they want to take your complaint to the federal. That's procedure. That's the protocol. And over again, Schultz and we the people get told that they keep violating protocol, and they won't listen.
Because they don't see this. They don't understand that they are not parties to the Constitution. They're not the posterity of the signers.
That is absolutely correct. And let me see if I can find that real quick. I want to pull up a document. It was a preamble to the Constitution. It was 10 pages that I wrote back at least 10 years ago, where I did 10 pages just analyzing the preamble. We, the people of the United States. People is capitalized. This is the entity, the people of the United States. And, of course, they got 6 commas in here where they say the reasons that they are writing this Constitution. They want to form a more perfect union. Okay, to form a more perfect union means they have to eliminate state sovereignty, period, because it's a perfect union. Okay, establish justice, ensure tranquility, allegedly, provide for defense, allegedly, promote the general welfare, allegedly, and this one I won't say allegedly about, and secure the blessings of liberty to ourselves and our posterity. People and posterity are both capitalized. That's the language procedure called a capita nim. It's kind of like any words you want to pick. Nice and nice. Nice is a city. Nice is not. One's capitalized, one's not. Same thing here. People and people are not the same word, and neither is posterity and posterity. If you don't know your posterity, you don't know your bloodline, and I guarantee you, you're not of the posterity, because they know who the posterity is. I've seen the pictures of even the ones that sit in office today. Looks exactly like the one that was sitting in office in 1865 called Andrew Johnson. I have pictures of it out of a book from the 1800s that showed all the constitutional acts from 1860 to 1880, had pictures of the 5 presidents, Ray, in that book that were sitting during those 20 years. It's the same bloodline of Andrew Johnson. Now, they do change their names. I mean, that goes on because they don't want, I mean, to keep the same names like they do in London with, you know, England, they know what the bloodline is. They all, king, queen, and royalty are all over there. Over here, it's the same way. They just like to keep it hidden. Power never leaves the posterity. I still want to go into the history of this. So I'm going to pull up the one that's called Say Excerpts and Comments. Let's go there first, because I want to talk about the right of self-determination and what the real solution is. Because the solution is not to keep complaining. Maybe I should pull up the historical perspective as well. And the reason being, Ray, is that you and I have talked about the history, how the Hebrews lost their self-determination when they had to sell themselves into bondage in Egypt. So they sold themselves into bondage. They lost their nationality, so to speak. They still had their ethnicity, but they were bonded. They became bond servants to Egypt, and they didn't get out of that condition and exercise self-determination again until they left Egypt. The answer was to leave Egypt. It was not to keep telling Pharaoh how to run things. It's incumbent upon us. We were put here to be stewards, and we were put here to take action. We were put here to be productive, and to sit around and wait is an abdication of our personal responsibility, and we were given personal responsibility.
Educational circles, the offspring of the posterity, learned they were different.
Well, they knew they were different from the time they were born because they were taught that. They were taught they were the posterity, and they were taught how they were going to rule over things. And one of the ways they rule over things is through some of the misrepresentation that we're talking about. I understand why the misrepresentation exists. It's up to us. My point about this to everyone, Ray, has always been, people say, well, they just hid this knowledge. I'm like, well, then how did I find it? How did people find this knowledge? The point is that they really didn't. They have always built they've always built the libraries. They've always put the knowledge out there. You know, when you seek the truth is when you find it, not when you sit around and pretend that you went to school and everyone just told you the truth and now you can go live your life happily ever after. See, the point is that's childish. And the reason it's childish is because it's acting like a first grader. The point is you have to grow up so that by the time you get to a desk in a college or a desk by being a CEO of a corporation or whatever, it's not the same size desk anymore, right? You did grow up. And so when you grow up, they give you a bigger desk. We have to grow up and understand that some of these things are our responsibility. Finding the truth is our responsibility. And it's not an easy task. No one ever said it was going to be, and it never said it should be. And anybody thinks it's otherwise, then, in my opinion, you're just fighting against and getting upset about things that you don't have to get upset about. This is great information for those that actually see it, hear it, and understand it. And it's not that hard to understand, Ray. That none of this is that hard to understand. Let's go into history. The Oregon Constitution and Article 1 Bill of Rights. Now, I didn't sign this Constitution. I'm not a party to the compact, but they left a clue behind in this document where it says we declare that all men, when they form a social compact, are equal in right. Now, I learned in law how to read things backwards, too. So men, when they form a social compact, are equal in right. That would mean that men, when they don't form a social compact, are not equal in right. The question is, when did you form or sign on to this social compact? If the state constitution is a compact, are you a signatory to it? Where's the document that stipulates, or the contract that stipulates that you're equal in rights? And if so, what rights? We're talking about the right of self-determination, so we'll go through a little bit of history here. I started with the Oregon Constitution, Ray, because they haven't hidden this. They're telling people for hundreds and hundreds and hundreds of years through the Law of Nations, which, by the way, is mentioned in the Constitution. And when I get in with these constitutional experts now, the first thing I ask them is, have you read the Law of Nations? And over again, they say, no, I haven't read the Law of Nations. I'll go, well, then how can you be a constitutional expert? since Article 1, Section 8 says that they had the right to define and punish piracies on the high seas and violations of the law of nations. What that means is they incorporated that entire book by reference to the book. And under Article 6, Clause 2, which is the National Supremacy Clause, it says that all the judges in every state shall enforce international treaty law. But the point about self-determination that they're not hiding in the law is in the law of nations. It's also here in documents, which this came out of the verbatim minutes of the UN Charter, or when they actually formed the UN, not the Charter itself. But man has learned long ago it's impossible to live unto himself. And if you go to paragraph 3 there, it says, for lasting security, men of goodwill must unite and organize. Okay, well, that's men of goodwill. Well, that would be me. That would be others who've chosen to exercise our right of self-determination, to unite and organize. Like Daniel, like Joseph, I'm not here to tell them what to do. I know I wasn't signatory, so I don't have a right to tell them what to do. But differences between men and between nations will always remain. In fact, if held within reasonable limits, such disagreements are actually wholesome. So we have a disagreement. Why else would we come out? Why did the founders of the United States of America write that declaration? They had disagreements with the king. And technically, when you look at the declaration, it was a document saying three things, basically. And one, we're going to come out and assume our position among the powers of the earth. But the rest of the document, until you get down to the pledge, the rest of the document is really nothing more than a tort claim. They're saying that all this stuff was moral torts. Now, this is the original declaration of the state of Maryland. So they're making a declaration. They declared. What they declared in number 4 was that all persons invested with the legislative and executive powers of the government are trustees of the public. Understand that these legislative and executive powers are still under the people who drafted this compact. And the public are the people that they're using this compact to subjugate. And people can choose to look at it otherwise, but this subjugation, they actually said in here, whenever the ends of government are perverted and the public liberty manifestly endangered and all other means of redress are ineffectual, the people may and of right ought to reform the old or establish a new government. The point is you're not going to reform the old. They didn't want it reformed when they set this thing up.
Number 4.
Yes. Yes.
And 5 and 6 and 7.
Just 4. 4 is all we're looking at the right of self-determination and why people do things. Why you should form a new government. You know, rather than trying to fix an old one where you have no right to redress because you're not signatory. What I want to do while you're trying to fix this, Ray, where you can hear me better, is go ahead and explain from a contract position exactly what goes on with forming a declaration or forming a constitution.
Breaking up, I can't hear you.
All right, I'm on page 5. We've shown the paddle for case and also 2 declarations where it talks about men signing on to a compact, being a party to a compact, forming a new government if the one that they're part of doesn't serve them. And when I say a part of, in this case, I'm talking about belonging to, not actually being the one that set it up. Under the law of nations, it was called the right of self-exile. You still there?
Yes.
Okay. Today, that right of self-exile is called the right of self-determination. But the point is, thinking about contract law, Ray, what we have to look at is, if men come together, like if the U.S. didn't exist and you and I lived in the same neighborhood, the same area, and there was 50 families, just like old Indian tribes and Hebrew tribes or whatever, when people come together to form their community, they sit down and actually either sign and write up or talk about and agree to how it is they're going to run the community, what the laws are going to be, who's going to, if there's a disagreement over contracts, if there's a disagreement over property, you have to have some kind of means of settling disputes. That's just the way cultures are. But you also have to have a means of supporting that culture, whether it's through taxation or pledges or whatever people want to call it. Now, if you and I sat down with 48 other families and we drafted up a declaration, this is our community, we're going to call it Rayville, and in Rayville, this is the declaration, and here we drafted up a charter or a constitution of how we're going to run things. Now, along comes another party, and they say, I have a right to your constitution. Do they have a right to our constitution? Okay. I mean, another family decides they want to move in. We get to choose and decide whether or not we want them to move in, right?
They're not signatories of our Constitution.
Right, and we don't know whether they're going to keep any agreements with us or not. So how do we know if we want them in the community? The point is, when we all signed that document, that became our intellectual property. We own it. We control it. It's no different than any other contract. You could take a real estate contract where two people are signed to transfer title equity on a property, and a third party comes along and says, well, I think I'd like to live in the upstairs bedroom. Well, where's their contract right? Same thing with declarations, same thing with compacts and constitutions. I don't fall for what allegedly is put into history. I see things for the way they are, because the way it's run right now tells me the way things were back then. They keep saying, don't bring that Constitution into my courtroom. Why? Because this is my courtroom, not yours. It's right in the Paddleford case in 1854. You are not a party to the Constitution. Quit bringing it up. And by the way, when you do, you're trespassing across their intellectual property rights. You're guilty of breaching international treaty law over international copyrights and trademarks, and therefore you're the tortfeasor and you're going to jail, period. Okay? Well, and it's right.
It makes perfect sense to look at organizations that have failed, because you see that they are doing nothing more than protecting their property and their rights.
Well, and the rights of the posterity that they work for, and enforcing international treaty. And copyrights are part of international treaty law, period. Well, I won't disagree that there's misrepresentation going on, but again, I go back to where does the responsibility lie? Said, return to me and I'll return to you. So people got to return back to truth. They got to return back to some intelligence and understanding. It behooves us to read what these people have been writing, because these people have been doing it right. Look at it. This is the Jamestown Exposition by Roosevelt. Men can never escape being governed. They must either govern themselves or they must submit to being governed by others. If from lawlessness or fickleness, what is fickleness? That's your unwillingness to pledge after you learn the truth, to set up your own government, your own community, come together as a people of like mind, to pledge to declarations and principles and concepts that you can believe in. Because, see, I don't believe in the concepts here. I'm not for abortion. I'm just not. And that's just one issue. I'm not going to get into tons of issues. It doesn't matter. There's a philosophical difference there, and it says that as long as those differences are held within certain parameters, they're actually wholesome. So I have a disagreement. And so for that reason, I'm going to look at it and choose to go govern myself in a different manner. And that's exactly what they're saying here. So if it's from lawlessness, fickleness, or folly, or self-indulgence, they've refused to govern themselves, then most assuredly in the end they will have to be governed from the outside. That's the way it is. The sovereign cannot make excuses for his failures. The sovereign must accept the responsibility for the exercise of the power that inheres in him. And that power means, in the world of the law of nations, you got a right to self-exile, but you don't have a right to tell us what to do. We're exercising our stewardship and our sovereignty the way we want to. If you want to do yours, then go somewhere else to do it, or go form it. We'll live on the same planet. We'll live on the same dirt. You know, the Indian tribes are here in the U.S., or actually the U.S. is here on the Indian tribes, or whatever you want to call it. It doesn't matter. All the nations of Europe at one time were not nations of Europe. It was like one big landmass. Okay, so people can peacefully coexist. So the sovereign can't make excuses. Let me go down to the next page. 6th International Conference of American States. The Conference of American States was formed in 1892. This was the 6th International Conference of American States. When I first saw this, I thought it was very interesting language, because I thought I knew that the American states to be something like South Carolina, North Carolina, Georgia. This says it's an international conference. Not only that, it's not the first one they had, it's the 6th one, and it was held in Havana, Cuba in 1928. This is right out of international law. This is right out of the treaties. It's right out of the rights and duties of nations. It's right out of the law of nations. And it says every nation has a right to exist, nation being a state. You know, like we come together, we become a state. That's our status, our status. We have a right to protect and conserve our existence. But this right neither implies the right nor justifies the act of the state to protect itself or to conserve its existence by the commission of unlawful acts against an innocent or unoffending state. So you got to come out peacefully. Israel did nothing against Egypt. They did nothing. They did nothing against Babylon. When Israel split itself, they did not go to war. The 10 tribes just simply left. They had a disagreement over taxation. Jeroboam went to Rehoboam. Here again, we're going into history, because this is how all of this applies. This is how the international community applies it. They're doing it right. Trust me, they're doing it right. When Jeroboam went to Rehoboam, he said, your daddy has been taxing us heavily, and we would really appreciate it if you would stop it now that he's dead. Which, meaning that Rehoboam was going to be taking over for Solomon. And Rehoboam said, well, if they think it was bad under daddy, then watch what Rehoboam's going to do. And Jeroboam said, well, we thought that you would say that, so guess what we're going to do? We're leaving. No more taxes from us. We won't come down here and participate in your feast. We'll have them up here where we are. Now, the point is that they didn't actually physically leave the land. They stayed right where they were. They just didn't have anything else to do with the other 3 tribes anymore. That's how the 10 tribes exercised their right of self-determination to leave the other state in peace and say, you know what, we have a disagreement. The disagreement's wholesome. We don't like the tort, so therefore we're leaving. We'll form our own state. We'll do our own thing. Every nation has a right to independence in the sense that it is a right to pursuit of happiness, as it is free to develop itself without external interference or control from other states, provided that in doing so it does not interfere with the rights of other states. Every nation is in law and before law equal with every other nation, belonging to the society of nations, and all nations have a right to claim, and according to the Declaration of Independence of the United States, to assume among the powers of the earth the separate and equal station to which the law of nature and nature's God entitle them. So they're already agreeing that we have this entitlement. As a matter of fact, there's plenty of other things that agree with that, Some people believe they were put here to be kings and priests. Well, then be one. That's what this says. Form your own state, form your own country, come together with people of like mind, men of goodwill, organize, and run a society the way you want to run it. And if you don't trample all over us, we'll actually honor you. The point here, Ray, is, and this is what the Father taught me, there is a way to be in the world and not of the world. There's a way to come out of her, my people, that, in my opinion, the Creator actually had them leave it in the international law, and they respect it actually more than the people that you and I would call the people that we've known for years. They believe it and respect it more than those people do, because those people are trying to get these other nations, these other societies to change their declarations and change their constitutions and change the way they run things, and that's a dishonor because they're not signatory to the contract.
Do whatever they're doing and making waves, making out of ignorance, and it's...
Well, if you look at Article 6 here on this same page, they're doing it under international law, because it says right here that international law is at one time and the same, both national and international. It's national in the sense that it is the law of the land, and that's what it says in the Constitution. It says all international treaties shall be supreme law of the land. This is running on international law among private parties, by the way. Private parties being the ones who are willing to form a compact, then they become a private party. Otherwise, they're just republicked inside someone else's public for their failure to stand up and form their own society and just want to go along to get along. I agree with what you said, that sometimes it's done in ignorance. Sometimes it's not done in ignorance. Sometimes it's just downright arrogance and refusal to listen. I didn't have that problem because I was seeking the truth, and that's what this led me to. My comment over and over again is, if people prove me wrong, that this is wrong. I had this in my mind back 7-8 years ago when I was looking at how am I literally going to come out of her, my people, literally. Not some kind of spiritual, ethereal, let me sit around and think about it. See, we're commanded to move. We're commanded to act. Because without action, then you haven't done anything. You haven't proven a thing. It's like people in business talking about the law of attraction, like they can sit around and think about how they're going to be attractive. You don't get attractive by thinking about it. You get attractive by motion. Just like when you create an electromagnet, you wrap a wire around a piece of metal. You shove energy through that, and it's the energy in motion that causes the attraction. So the only way to be attractive is to move. We were talking earlier about people don't have the funds to do this or do that. Well, then why are they working for other people? Why don't they go in business? Why don't they create? Why don't they move? Look at the movie Forrest Gump. I wrote about this years ago. I have it on my website. Forrest Gump, he was constant motion. But because he only focused on one thing at a time, he was successful at everything he did. Not because he thought about anything, he was incapable of doing that. So the same thing is true here. We read and study so we can learn and contemplate what's written. But in understanding international law, this is being done under the law of nations. This is how you come out. And they're saying everyone's got a right to do it when they form the state. If you'll see the next page under Appendix 6, the convention that they held was held for private international law. These are the American states, by the way: Peru, Uruguay, Panama. Anyway, so these were the 9 articles that they passed of private international law. This was what the convention was all about. I'm not going to go through it, but it does say in Article 6 that if a nation was a non-contracting state, meaning they didn't show up at the meeting, I'll just read it. Non-contracting states are international juristic persons desiring to adhere to this convention. What does that mean? Desiring to sign on to the treaty, they can deposit in the Office of Pan-American Union the instrument of adherence. The Secretary General has a duty to contact all the contracting states who are signatory at these conventions, at these treaties. And after 6 months, if there is no disagreement, it says in here, shall reciprocally be bound by the convention 30 days after the adherence. So if there's no disagreement within the 6 months, and if none of the other states have any problem with it, then they're in. This goes back to silent acquiescence again, because that adherence document becomes the evidence of service and process that you are party to. Now, if the state was not there, or they did not even exist at the time, because there's plenty of nations that, didn't exist at this time. This was in 1928. If they wanted to be a party to these treaties and agreements, they have to deposit with the OAS now, the Organization of American States. Go down to the next page, you're going to see that they talked about the private international law and the code of private international law. This is how they pass these private international laws and then take these codes of private international law and put it into all their disparate jurisdiction under things like the U.S. Code. And this is how they're going to treat the republics, the public that are in their republics. Key in on the language, foreigners belonging to, that means people belong to something, as in property. Foreigners belonging to any of the contracting states enjoy in the territory of the others the same civil rights as are granted to nationals. So this is not a political right. These are people that belong to a state. But here's the real key. All of these principles are under this doctrine, under Article 3, Section 2, these civil rights and enjoyments of identical individual guarantees are binding alike on all persons residing in the territory, whether or not they are nationals, and these rules are termed to be territorial, local, or of an international public order. What they're saying is we're going to maintain an international public order. Article 4 says the same thing. Constitutional precepts are of an international public order. They are not of just a national public order. They're international in scope. I won't go into more of that because the international public order is what we call it now, the IPO, International Public Order. Going down to the next page real quick, there's one statement right there. This is just to solidify what this self-determination is all about and who's saying it and why they're saying it, and whether or not it's valid about what I'm saying about it. Well, this was Truman in 47. We believe that all people who are prepared for self-government should be permitted to choose their own form of government by their own freely expressed choice without interference from any foreign source. So if you do it peacefully, they say they're not going to interfere. And that don't mean they're going to help. They ain't going to interfere. Down to the next page. This is the Declaration of Principles of International Law concerning friendly relations and cooperation among states in accordance with the Charter of the United Nations. Bearing in mind, this is the third paragraph, bearing in mind the importance of maintaining and strengthening international peace founded upon freedom, equality, justice, and respect for fundamental human rights, and of developing friendly relations among nations irrespective of their political, economic, and social systems or their level of development. In other words, you don't have to have a big level of development to come out. As a matter of fact, the founders of the United States of America didn't. People say, well, they were the big wealthy landowners. They did control a lot of equity, but technically they didn't own any land. That was all given by grant of the king. The king owned the land. So they were not big wealthy landowners. They didn't own anything. Not at that point. Now, it was different when they came out. Now, they did some things wrong. We have to look at that. People look at that declaration who think they're party to it, by the way. That's why they think it's so sacred. They're not party to it, and so they don't understand the errors that were made. One of those errors being that these men said that all men were created equal. Well, they didn't believe it. That's why they had slaves. So that in itself is shocking to the conscience of the universe.
You made it clear they're not a party to it, then they're not committed to.
They're not signatory. I mean, if people haven't gotten that yet, they're not signatory to the compact. The Constitution was not created for you. It was created for you because as a constitutor, if you go into Black's Law, Ray, and you know I'm again keying in on words, constitutor, it says that it's one who by simple agreement becomes responsible for the payment of another's debts. Well, since the USA and the U.S. are both indebted to the international creditors, and then since Americans under law, where they have surrendered all rights, all title, and all interest, you have no right, you have no title, you have no interest, therefore you have no claim. You can't state a claim, but if you want to keep thumping that Constitution, then pay the debts and just go along to get along, because that's what you've agreed to. I didn't make it up. That's their copyright. They put it in their books. I do get to read their books. You know, and constitutors, by simple agreement, become responsible for the payment of someone else's debt. So if you're going to agree to be a constitutor, then pay the debt, and what are you disagreeing with? And under the 14th Amendment, it says that if you, as a U.S. citizen, and a U.S. citizen means a state citizen, a national, a resident, an alien, they're not signatory to the compact, therefore they have no political rights, they have no political standing, therefore they're granted civil rights. And as a citizen, as an American, whatever it is, with no rights, no title, no interest, no claim, it says that under the 14th Amendment, you have to pay, you cannot dispute the debts of the United States. And if you do dispute the debts, you are guilty of insurrection and rebellion, and anything it costs them to crush your insurrection and rebellion, they will charge it back on you again. That's the system, period. Principle of equal rights and self-determination. By the virtue of principle of equal rights and self-determination of peoples enshrined in the Charter of the United Nations, all peoples have a right to freely to determine, without external interference, their political status and pursue their social, economic, and cultural development, and every state has a duty to respect this right. I'm going to go down to the paragraph where it's underlined here. The establishment of a sovereign and independent state, the free association or integration with an independent state, or the emergence into any other political status freely determined by a people constitute the mode of implementing this right of self-determination by that people. As every state has a duty to refrain from forcible action which deprives people referred to above in the elaboration of these principles of their rights of self-determination and of freedom and independence. Okay? But this freedom and independence means taking responsibility. You now have to form your own, you now got to support your state, support your society, support the declarations that you believe in. That's what they've always done, and that's why they respect it so much. I know, I've been through this, Ray. We've talked about it. I've seen them return honor for honor every single time. With me, when they wrote me as an ambassador, when I had to go testify in court, when they accepted my documents, you know, it was a fearful thing. Because, I mean, even though I knew this, I didn't understand that they would honor it. I've been told this, but they're not going to honor that. They're not going to honor these international treaties. And then in the same breath, they'll go, well, don't I have a right under this code? You just said that they don't honor anything. So you're telling me they won't honor an international treaty, but you think they're going to honor a code. The point is, I've seen it. They do honor this. That's why they've written me the way they did. Maintaining this international public order is the key, not trespassing across other states. The Declaration of Rights and Duties of Nations, this is another treaty. The political existence of a state is independent of its recognition by the other states. The state has a right, even before recognition, to defend its integrity and independence, provide for its maintenance and prosperity, to organize itself as it sees fit, to legislate its own interests, to administer its services, and to determine the jurisdiction and qualification of its courts. The exercise of these rights has no other limit than the respect for rights of other states in conformity with international law, and that would be to keep the peace, period. Let's go to the next document, the rights and duties of individuals. I'll just show you where people that are going into these courts don't have any rights to go in there and say anything. Under Article 7, close to the bottom down there, it says every individual is entitled to be protected and assisted by the state to which he belongs. Do you see the same language there that was in the International Convention that was held in 1928?
Yes.
Same language, to which he belongs. This has nothing to do with political rights. It has to do with the rights and duties of individuals who are under someone else's constitution or compact because they have failed and not taken the responsibility to come out and exercise the right of self-determination. Every individual is entitled to be protected and assisted by the state to which he belongs in a manner established and a form established by treaties and by international law. Again, the international law is supreme, period. And the Constitution is an international document maintaining international public order. No individual who, according to the law of the state against which he institutes a claim, and I don't care if it's an administrative claim or a lawsuit in court, as a citizen of that state, be he state citizen or whatever they think they are, they will not be entitled to any such protection.
You made it clear if they're not a party to it, then they're not entitled to.
The point is, if they belong to the state and then sue the state or file a claim against the state, be it on a UCC or be it in the court or wherever they file it, then they're not going to be entitled to protection. They've now sued the state. In the U.S., the last time I checked, and I've been doing this for about 8 to 10 years now, if you lose protection of the state, then you become public enemy number one. You become a paper terrorist. Actually now, as far as the state citizenship stuff, Ray, I got a court document here. State citizens now are not just called paper terrorists, they are called domestic terrorists in the court. They will be crushed because it's a violation of Patriot Act, it's a violation of Homeland Security, it's a violation of now what they passed last year, which was Senate Bill 1959, to crush ideological terrorism. And it is ideological terrorism because you're coming in and claiming that you're signatory to a compact on a state that you're not. So you're
Makes it very clear. It makes perfect sense. Eliminate the confusion and the threat and the disorder is being perpetrated. And again, most of this, I can't say all of it, I would say 99% of this disorder is from the lack of knowledge or understanding of who they are. They don't know who they are.
Well, part of this is done by ignorance. Some of it's done with good intent through ignorance, but it's still ignorance. So, the good intent from the system, they don't care one way or the other. It becomes questionable. Well, let me tell you a little bit.
Time out. That means time out in Cuba.
Oh yeah, they got plenty of those for people. Their code is copywritten. The only people they give a license to practice with that code are the attorneys. Period. You don't have a right to practice with the code because it's under copyright. People say, well, they published it in the Federal Registry. Fine, they published it in the Federal Registry. So what? Where did you get your contract to practice with it?
So a pro se or pro per recognized.
It's all for show. It's all for show. They can do whatever they want. If you're suing the state, what is it? It's already said right here. You can't. You lose all protection. You cannot. And it's in the international treaty law. You have a right to self-exile. You have a right to self-determination. You don't have a right. Original Declaration of Maryland. If you got no redress, it's time to do what? Form a new government. Any of the examples I said in history, as I know people get upset about this, Ray, but any examples I said in history are still valid. And this is what the international community realizes. They keep telling you, they do it right. Jeroboam and the 10 tribes left. Some of the people went back from Babylon to Jerusalem, and Israel left Egypt. They didn't go to war either. They got pursued. No, allegedly, I've heard it. The point is that according to what that says, these people didn't pick up a sword, and they didn't keep complaining anymore. They left. There again, like I said, doesn't necessarily mean you got to leave the dirt. When Jeroboam and Rehoboam and the 10 tribes, they didn't leave the dirt. They stayed where they were. They just formed a different state. Same thing on this document, too, down here, by the way. No alien may interfere either directly or indirectly with the politics of the country in which he happens to be, or claim any enjoyment of any rights or assertions of any other rights, such rights other than those provided for nationals by the Constitution and the laws. So nationals are under the Constitution, meaning under. Okay? Aliens shall be obliged to respect the political, social, and economic regime prevailing in the state in which they reside, and to observe and obey the law and provisions enforced therein, and to submit to the jurisdiction of government authorities and of its courts of justice. Now, this is saying that aliens have the same rights as nationals, which is to submit to the jurisdiction and decision of the governmental authorities. Period. Nationals have to submit. They don't have any political rights. They have civil rights, and those rights are granted. Those rights can be taken away, and I'll show that in a different document when we get to the notes on the state of Virginia. Go down to page number 17. I'm going to read this. Basically, what these people did, this is talking about history. They got upset one day and they said, we're tired of being oppressed, so what this means, we have to take responsibility for all these services that the king is supplying. Okay, all these rules of protection, courts of mediation, other schools of education, we want to set them up because we want to protect our rights, where the previous is not doing so. We want to educate our children the way we think instead of the way they think. Because I guarantee you, when somebody sets up something, they pass on the knowledge unto the posterity of those things in which they're going to rule, i.e. the posterity today. By the way, Ray, so I have some documents on it to show international treaties that the U.S. started signing, you know, where it says in Article 6 that that the U.S. had the authority to sign international treaties. Back then, in the 1780s, 1790s, the treaties I found literally said the United States of America, or the United States of North America, or the United States, whichever the treaties were, depending on the period of time. Because after 1789, it was the United States that had the right to sign the treaties, not the United States of America. But it also uses the language that says their possessions and their subjects. I'll never forget rereading that. I think it was in the first treaty I read with the King of Morocco, and I was sitting there going, well, wait a minute, who are these U.S. subjects? They changed the word to citizen, you know, then they got into that stupid argument about capital C or little c. The word citizen is still a subject under someone else's constitution because you failed to come out and do your own compact. Anyway, what it says here, so as I was explaining to the gentleman outside, if you're not a party to the contract, i.e. the Constitution, or a signatory to the contract, you're known as what? A wild deer, an antelope, and they like to have those things because they like to eat them. They give license to those who like to go out and suck on them. We know they're called the police, or they're called the attorneys, or they're called whatever, until you realize that you are in that state as a refugee, just like the deer or the antelope. Then the secured party creditor, that's the SPC right there, that last sentence, secured party creditor standing has no bearing. That's why redemption does not work 100%. Redemption cannot work 100%, because the way off the plantation, the country, the state, the county, was more aptly put the way divine law works. Divine law works under contract law. And when you're given a presentment without standing, you have no standing to state a claim for which relief can be granted. And if you're a refugee under this law, refugee meaning you're not signatory, you have no standing other than the jurisdiction of the state that you're found in. And if you cannot state otherwise that you belong to something else, i.e. the alliance or the dominion, like I am, and prove it beyond the shadow of a doubt, then you're lost. Not in the sense of the way they're treating you, because you ain't ever lost to them. You're bound to them, just like the deer. They have a license to hunt, and they're going to eat it out until there's nothing but bones and dust. So if you will go into the Encyclopedia Britannica under international organizations, you get an idea of what it is. Now, they exercise, and what I mean by those who are willing to self-govern are exercising power. You know, people who are signatory to the Charter of the United Nations, otherwise known as the OUN. That's why it's an organization. It's the OUN, not just the UN. They dropped off the O because they wanted you to think it was a government, but it's nothing more than an organization, an IGO. There's other ones like NATO. And they have a lot of power. That's because they're willing to put up value and take responsibility for that power to be exercised. If you're not going to put up something to support the exercise, whether it's the alliance or something else, then they'll always assume that you belong to them or whoever finds you. So the point about how this works with the alliance, under international recognition, according to these encyclopedias, there was about 10 of these IGOs in 1850, and today there's about 2,500 of them. Now, they've tried to take some of the power away from these organizations by making them non-governmental, or NGOs, which means you're under the control of the mother organization called the OUN. And the fact is, there's a lot of people who are falling for that, who want to have a voice to speak. The point is with NGOs, is you don't have to fall for it. You can actually become a part of a supranational intergovernmental organization. Now, the medium word here is supranational intergovernmental. What controls that? Well, you draw up the contract or the compact, you sign it, you say what you're going to do to support it. Your pledge. That's what the founders did. They were the ones that built the ships, the boats, and they actually paid the Continental Army, which was a mercenary army, who did not pledge, by the way, which is the reason they had no right to the compact. As a matter of fact, they all revolted when they didn't get paid, which tells me that they didn't pledge. If they'd have pledged their life, their liberty, their fortunes, and their sacred honor, then they wouldn't have been worried about whether or not they got paid, because they would have been the ones paying to have their freedom. A contract is called a charter or constitution or whatever you want to call it, but unless you've got it, you can't treat with them an authority, because someone else is always going to claim you. Does that make sense, Ray?
Yeah.
No. Okay. Exactly. Let's go down to 21 juridical constructs. There's one thing I want to go through here, and then I'm going to start pulling up some other things about the UCC and show you why. You've been talking to me about Freedom Club USA, about Dorian Group, these people who were doing bonds, bills of exchange. What I'm telling you is they don't have standing to state a claim, which means they don't have standing to do what they're doing. They don't have a claim. They don't have an administrative remedy. They don't have a claim because they're doing it against the state that they belong to. Okay. This is about establishing a juridical construct and how it's done. Now, this one was something Arthur wrote, and it just blew my mind because this had to do with Civil Rule 9A relative to Civil Rules, the Rules of Civil Procedure 12H3. Wouldn't it be nice if it were so easy to make a mere suggestion as to promulgate 12H3 and obtain super sponta the imperative shown based on the absolute free choice of tacit recourse for failure to rebut the specific negative averment in Rule 9A? The only way for me to explain this is to go to Rule 9A. So at this point, what I'm going to do, Ray, I think we don't need anything else. I'm going to pull up an internet browser, and we're going to get into a specific. We've gone through what the right of self-determination is, and also the rights and duties of individuals, why people don't have a right to file these claims. And if they don't know yet what's going to happen to them, then just consider what happened to Dorian. They went to jail for 25, I think it was 25 years the sentence is. Right. And now you're telling me that there's a possibility they're going to come back with even more charges. So they don't have standing to state a claim. But I'm going to actually just let's go to Title 18. I'm going to show you exactly what they're violating. Exactly. So we'll talk about Rule 9A and Rule 12H3 in just a second. Okay, well, I'm just going to go through this real quick. I want to read it to you, Ray. I'm under Title 18, Part 1, which is crimes. We go down to Chapter 19, which is conspiracy. Oh, nope, I'm wrong. We go down to 47, fraud and false statements. Because this is what they're doing. This is what it is. It's fraud and a false statement because it's violating treaties. It's violating copyright. You're a tortfeasor. You trespass across someone else's intellectual property right. And you're making a demand. And the demand appears under Title 18, Section 1003. It's a demand against the United. This is under Title 18, 1003, because I've seen this charge on people before who've done bills of exchange trying to do whatever they were trying to do. One guy was finally told years ago, I can't remember his name, it was Ben something, it was in South Carolina. What they told him, what you've done is you tried to tap the stock of the United States. What's that? What's the stock of the United States? Who's the stockholder? Of course, I already knew because I understood the posterity. They're the stockholders. Anyway, whoever knowingly and fraudulently demands or endeavors to obtain any sum or share of the public stocks of the United States or any part there transferred, assigned, or sold or conveyed, or have any annuity, dividend, pension, wage, gratuity, or other debt due from the United States, or any part thereof received or paid by virtue of false or forged or counterfeited power of attorney, authority, or instrument, shall be fined or imprisoned under this section for not more than 5 years, or both. The point is that this is the charge. This is whether they actually put it there or not. Now, if they don't get them on this one, they're going to get them for mail fraud, bank fraud, all these other kind of things. And the mail fraud one's hard to overcome because the post office is powerful. All right, let me go back real quick. I'm going to go into OAS.org in just a second to solidify what I just read out of 18 Section 1003. We'll go down to Title 28 real quick, though, and talk about what was just mentioned under juridical constructs, how under 9A, this has to do with pleadings and special matters, capacity. It is not necessary to aver the standing or capacity of a party to sue or be sued, or the authority of a party to sue or be sued in a representative capacity, except to the extent required to show the jurisdiction of the court. This is a waiver. So they're saying it's not necessary to aver your capacity. Well, why would you want to waive your standing if you have standing, right? Because that's what's going to show the extent of the jurisdiction of the court. When a party desires to raise an issue of the legal existence of any party or capacity of a party, i.e. the standing of that party to sue or be sued, the party desiring to raise the issue shall do so by specific negative averment. Now, I've seen people do tons of specific negative averments, and this is what I missed for years, and I wanted to know, what does this mean right here? Which shall include the supporting particulars as are peculiarly within the pleader's knowledge. I said, what does this word particulars mean? Because obviously I don't know what it means. Because they've ignored everything in terms of what I consider to be a particular. i.e. I'm sovereign, I'm an American, and the particulars they're talking about is your pledge to something else, which says that you have assumed your position among the powers of the earth, and you've pledged to support different declarations, and you're going to quit usurping and trespassing across their private intellectual property, period. Okay, now once you do that, once that's done, then we go to 12H3. 12H3, that wouldn't it be nice if we could do this? And it is nice because I've seen it work, and I've seen it done, and I've seen them honor it. That's what I'm telling you, Ray. They're doing it right, and they give honor where honor is due. It says that waiver or preservation of a certain defense whenever it appears by suggestion of the parties or otherwise that the court lacks jurisdiction of the subject matter, the court shall dismiss the action. Without those particulars, they're not dismissing because they own it, they control it, they have the copyright, and if you've trespassed it, they're going to take those actions. I want to go back real quick. Two places I have to go. One is into the UCC. There's a code that people ignore completely in the UCC because they think they have a right somewhere. If they don't understand it by now, they don't have that right because they don't have standing. I have seen this stuff work against individuals, from individual to individual, and from individuals to corporation, and from corporation to corporation. But under international law, you cannot file that claim against the state you belong to, period. That's it. All right, under UCC 5116, this is the linchpin to the entire UCC, is the choice of law and forum. The liability of an issuer, nominated party, or advisor for an action or omission is governed by the law of the jurisdiction chosen by an agreement in the form of a record. Okay, you file a UCC 1 in the state of Georgia. Didn't you just choose your law and your forum as Georgia, Ray? Okay, so now Georgia owns your document. That's your law forum. You've submitted to that forum. You don't have your own state. You haven't set up your own UCC wherein you're going to file and own your own documents, your own commercial instruments. The point of this one is, when you look at treaties and you look at these records, the jurisdiction of the law chosen need not bear any relation to the transaction. I'm going to go down to C here and read this real quick. Except as otherwise provided in this subsection, the liability of an issuer, nominated party, or advisor is governed by the rules of practice. If this article would govern the liability of an issuer under subsection A or B, or if the relevant undertaking incorporates rules of custom and practice, or if there is a conflict between this article and those rules applied to the undertaking, those rules govern except to the extent of any conflict with the non-variable provisions specific to section 103C. Non-variable provisions, what is that? This is where we can do, once we come out, we can do, that's what treaties are. They are a variation of agreement, and they become non-variable when you have those variations of agreement in place by agreement with the Society of Nations. This is about peace again. You're setting up these variations of agreement so that you know how you're going to treat and treaty with one another. And under 103C, it says, with the exception of this subsection, it says the effect of this article may be varied by agreement. There's your variation of agreement right there. It may be varied by agreement, provided you got standing to vary the agreement and they agree to it. And they also can agree by acquiescence, by the way, as long as you know how that works and how it's done. Because the acquiescence, according to their conventions, which we read earlier, can take up to 6 or 7 months. But it doesn't mean that anyone's going to respond. It just means that they acknowledge your adherence and they've got your document. So they've now agreed. Whether they signed it or not is irrelevant. You gave them notice. And when they didn't disagree, they then agreed. This was so critical in finding this in the UCC, I can't even tell you. So these people that are doing these bonds, doing this stuff, filing their UCCs, allegedly doing administrative claims, which they don't have a right to do under the rights and duties of individuals because it's a claim against the state to which they belong, and they have no variation agreement under this UCC. Do you see how all this ties together, Ray? It all ties together. They don't have standing to do this, and they don't have a variation of agreement to do it. And you could do it before or after, but you can't do it unless you got stand. You can't do it in their rules, under their code, under whatever, U.S. Code, Title 28 or whatever. It says that tort is the exclusive remedy. The word exclusive means exclusive. There's only one remedy, and it's tort. What they're doing, what these other people are doing, Dorian, Freedom USA or whatever, it's not tort. They're not trying to get to where they come out of my people, have rights, have standing, negotiate for and barter for a settlement on the tort issue They're just trying to use the system against the system without a right to do so, because you have private international law, public international law. So if you're not a party to private international law, you don't have a right under, when they did this convention, which was in 1976, this is when they changed the organization to the International Conference of American States, became the Organization of American States. Then they, in 47, their first convention was not held actually until 76. They did CIDIP-1, which was their convention. They adopted 6 treaties or 6 conventions, the first one being the Inter-American Convention on Conflicts of Law Concerning Bills of Exchange, Promissory Notes, and Invoices. This is how they handle promissory notes, bills of exchange, and invoices among each other. Why? Because every government owns their banks. Every state owns their banks. These are U.S. banks. They're insured by FDIC. They're Federal Reserve banks. However you want to look at it, they belong to the Treasury. And they're dealing in deposits of public money. That's under, you go look at Title 12, Section 90. They are deposits of public money. So when you become a signatory to a bank account, you don't own the bank account. The bank owns the bank account because it's public money. You become a trustee of public money. But the bottom line is that if you're not a party to this convention here where they've already agreed how they will handle a conflict over bills of exchange and promissory notes, then you can't do them. Unless the state that has an agreement on this contract allows you to do them. And people say, I've had people all the time say, well, we're just agreeing. We're going to stay in honor. We're going to offset and adjust the debt. Well, they haven't agreed that you can offset and adjust anything. People say, well, I don't have a conflict with it. I go, yeah, but they do. Why? Because they're signatory and you're not. You trespassed. Now they have a conflict. Whether you got one or not is irrelevant. Why? Because you didn't have the agreement. You created the conflict. Does that make sense?
Yes.
Okay. Wow, this is going long, but, maybe we can wrap this up here. U.S. Code, Title 12, I mentioned Section 90. People don't read their bank contracts. They don't read the signature cards.
When you sign your name to sign without recourse,
you don't have a right to sign without recourse.
Understood that was so that in case you were signing something that would make fraud, so that you would not be liable for fraud.
I know there's people who do this kind of stuff and they'll go void where prohibited by law, and that was under Article 5, 103C. We were just talking about whether or not you could vary these agreements. A term in an agreement or undertaking generally excusing liability or generally limiting remedies for failure to perform obligations is not sufficient to vary the obligation. So they took care of that one too. You actually have to have the variation by agreement, because it says in here that just making a statement like that in an agreement or undertaking, generally excusing your liability, like without recourse, without prejudice, void where prohibited by law, all that kind of stuff, it's not enough to vary the obligation. That's what it says right here. Okay.
So that they closed that loophole.
Yep. Might be one for them. It might be one for one who has standing, but it's not one for one who doesn't have standing. Yeah, exactly. Let's see. All national banks under Title 12, Section 90, all national bank associations designated for that purpose by the Secretary of Treasury. By the way, this doesn't say United States Secretary of Treasury. Shall be depositories of public money, and under such regulations may be prescribed by the Secretary. They may also be employed as financial agents of the government. What does that say? That means national banking associations are financial agents of the government, and they shall perform all reasonable duties as depositories of public money and financial agents of the government, as may be required of them. The Secretary of Treasury shall require the association thus designated to give satisfactory security in the form of deposits of United States bonds, otherwise in safekeeping, for prompt payment of public money deposited within them, and for faithful performance of their duties as financial agents of the government. What's the point here? When you sign a signature card, you now have an agency relationship with a financial agent of the government. Therefore, you're a financial agent of the government. You're a trustee dealing in deposits of public money. And they're the ones that sign the account number. Why? Because it's not your account. You're a trustee over the account. They're the grantor. And if the grantor decides to replevin that property, they will do so. And that's why if you read the signature cards and all that kind of stuff, it says, and they did it to me. They proved it to me back in 99. When they told me we can take your money anytime we want to, because they did. We lost over 1.2 million, Ray. They did it. Not because they were ignorant, because I was ignorant. That's what she told me when she said, if you will read your contract with this bank, I can take your money anytime I want to. Now, by the way, this is also this bank contract where, if you read the deposit slip, it says checks and other items are received for deposit in accordance with the provisions of the Uniform Commercial Code and any applicable bank collection agreements. The IRS agreements are right there in that signature card. They don't have to ratify Title 16 because you ratified it in your personal contract when you became a public trustee. And under the Constitution, as far as that one is concerned, you're holding now an office of honor, trust, or profit under their Constitution. That's what it says in Article 1 and Article 2 about holding offices for honor, trust, or profit. See, it told you right in the Constitution it was all about profit. People always say, well, if they look at the code, they'll go in the definitions section of Title 26, Section 7701, subsection 26, where it says trade or business, and they'll say, well, I'm not a trade or business. It says it says to be a trade or business, you have to perform the functions of a public office. Well, if you're a trustee dealing in public money, guess what? You are performing the functions of a public office. You just ratified into your own life, into your own contracts. They don't have to ratify anything because they're not going to bear the obligation of that contract. Okay. Oh, this is just other things, Ray. Do you have that little document? You've seen that document about the attorney-client relationship? It says a client is one who applies to a lawyer or counselor for advice in direction or in a question of law and commits his first duties to the court and to the public, not his client. Okay. Yeah, going down to the bottom of that, it says that clients also called wards of the court. And the word war is inside the word war. I mean, the war is inside the word ward, right? In other words, ward, that would be W-A-R-R-E-D. You ward against us. Now, therefore, you're incompetent. You're in dishonor. Because wards of the court are if it's the persons or persons of unsound mind. Why? Because this is about peace. It's not about war. You have to understand, Ray, when we go back to what we talked about with the rights and duties of individuals, this is a catch-22. Without a doubt, it's a catch-22. So how do you solve the catch-22? There's only one way. Come out of her. That's it. There is no other way. Let's see what else we want to talk about here. I'm going to pull up. I'll go back into Word. I had other Word documents up. Attorneys? Yeah, that I know. Federal Rule 9A and 12H3. Yeah, we're finished with that. I have a document called See and Hear. I think I have that up right now. The notes on the state of Virginia. We'll go back into history just a little bit more. The Armand Kondo letter. The Kondo letter, I'll go through this real quick. I'll point out one thing that he said. See, this whole taxation protest stuff, it's been going on forever. There's nothing new here, and they keep regurgitating, just like Freedom USA has done, Dorian did. They regurgitated the same stuff that the Freemen did in Montana. If you actually read and study what they did, the Freemen were not doing what everyone thought they were doing. And there was a lot of stuff that was right. But the issue came down to one thing, standing. They didn't have standing to do it. The rest is history now. But people keep regurgitating that history without the standing necessary to do these things. Pulling up this See and Hear document, we'll go back one more time and look at this rights and duties of individuals, which is the first document here. Every individual is entitled to be protected and assisted by the state to which he belongs in a manner and form established by treaties and international law. No individual who, according to the law of the state against which he institutes a claim as a citizen of that state, shall be entitled to any such protection. I wanted to once again show that if you're an individual belonging to a state, you can't sue the state. It's international law. It's been in the law of nations since the 1200s. You got the right of exile. You got a right to leave. You got a right to self-determination. But stop your whining, quit complaining, and just leave. We don't want to hear it because they're not going to change. Under this, there was 9 cases that were researched to show the general immunities pertaining to prosecutors, judges, and government agents. This is why you can't sue the state, because here's what happens. Okay, hang on one second. Okay, we're back to general immunity. Prosecutor may violate civil rights in initiating, prosecuting, and presenting case. Immunity extends to all activities closely associated with litigation and potential litigation. And there's the case site, Second Circuit Federal Court of Appeals, Davis versus Grusmeyer, Embler versus Pogman. In the first one, prosecutor may knowingly use false testimony and suppress evidence. They can do this. They're immune. This is how they govern their citizens. Prosecutor may file charges without any investigation. Prosecutor may file charges outside his jurisdiction, Myers versus Morris. Prosecutor may knowingly offer perjured testimony, Jones versus Shanklin.
Do whatever they want.
Correct. They're immune from whatever they do because they don't have standing. Kurt and Scott don't have standing. They don't have standing to state a claim. They're citizens. They filed claims against the United States. They lost all their protection, and they're just being ground into fine powder now.
You have no state.
A trustee of what? Property that belongs to the United States? Like being a trustee for one of its citizens, which is their property under the Department of Human Resources. And they didn't have any agreement through the OAS or through the Hague for any settlement of conflicts of interest or conflicts of law over promissory notes, bills of exchange, or invoices, which they did plenty of. They did plenty of bonds. And so when the U.S. decided they had a conflict with it, they went, okay, how are we going to settle the conflict? Oh, you boys don't have a contract to settle conflicts. You must be trespassing across our rights. Now, they didn't tell them that, and they're not going to.
You think somebody would have told them this?
The reason why I'm doing this with you today, Ray, is because this has come up 3 times for me now in the past 2 weeks. I don't know why it came up 3 times, but, you know, hey, if it takes forever to go through this, all I can say is, well, if it keeps you out of jail, because I know I've seen it, but I've also seen the other side of it where they give honor where honor is due for people who choose to come out. They put it in all the movies, Ray. It was in the last Matrix movie, remember? Matrix 3. What about those who still want to leave? You know, will they be allowed to leave? He said, of course. You think I'm human? This was the gift that I was given to see that these words mean something. The humans was the hue of the moon because why? The moon is in darkness. You have to have a moonarchy to rule over the moons, which is why they gave them that. And now when I say they, I'm talking about a universal thing. A constitution is Roman imperial law. Why would anyone want to be under Roman imperial law? The old words. Why did these systems form up the way they did? They're just as tired of the incompetence as any. They've watched 4,000 years of incompetence. People not wanting to live in honor.
Something happened to have the U.S. go on the offensive.
Well, first of all, when we read the Paddleford case and you read that thing about silent acquiescence, and it said silent acquiescence in the breach of a treaty binds an entire nation. Okay, well, that tells me that somebody there, probably the head, violated international treaty, violated some agreement that was already on the table. Do I know that? No. People say, well, what agreement did he violate? I don't know. I guess it was private international law, meaning private contract that I'm not privy to. But I guarantee you that they did not go in there without a reason. And since he breached the treaty, it bind the entire nation.
They can take it out.
I think the thing is that people get upset about this, Ray, but I don't get upset about it. I'm not going to sit here and judge how they think. I'm only worried about how I think, and I'm only worried about what it is that I do. And can I live in honor with myself and live in with honor with what I say in my contracts and my agreements? That's the real bottom line. Can people do that? Trust me, they look at the sacrifice they made to get to where they are, whoever they are. And there's an element of it where even when I had to go to court, and I was talking about that, Ray, and I've mentioned this to you several times, I'm telling you, nothing's happening without the Creator's permission or with direct involvement, and He is very close. He's in your face. What are you going to do in relation to coming out and living in honor? And someone's here to monitor that. I don't know who, but I have experienced it. I have seen it.
You want to be honored.
I understand that. My point is that when these people do things like what we're talking about with Dorian, or the people who have the agreements are just looking at what's the contract? What's the agreement? Did you have a right to do this, or are you trespassing on our right? And if you are, we have a problem.
What happens then?
Well, you lost the home because you didn't have the standing to keep the home.
5,000.
They could come after those people if they wanted to.
Well, I realize that.
I mean, look at what we got here. Prosecutor can suppress exculpatory evidence. Prosecutors are immune from lawsuit for conspiring with judges to determine the outcome of judicial proceedings. Prosecutor may knowingly file charges against innocent persons for a crime that never occurred. I can tell you how they can get all them 4,000 if they want them. It's called misprision of a felony. It's called you were involved. You were in collusion with it. You had contract with it. People say, well, we got damaged. The system's going. The ignorance of the law is no excuse. Now, are they going to? No, they're probably busy enough. They're all chasing somebody else. They will do whatever. For these principles, I already had the idea 7 years ago of creating our own state. I mean, I had told Sherry when we were living offshore, we were living in Caribbean. I had told Sherry that, it would be great if we created a place where people really could come out of her, my people. Now, back then, it was more of a religious thing. I don't get into that anymore because I believe in the rights of all people. And I don't care what people believe as long as they can live in honor with their agreements with me. If they want to believe whatever, I'm not here to tell them how to believe in the Creator. I'm not here to do that. Exactly. I'm not here to tell because by me telling someone else how they have to believe in the Creator is my interference with their sovereign right to choose how to believe how they want to believe. And if I believe that all men are sovereign, if I do believe that all men have a right to that, then I have to believe in their ability to choose. I want to need to wrap this up because I got to get going, but I'm going to try to produce this. I'm going to try to put it up onto a website, and so that other people that I've been talking to can actually just go. They can see it. I've got the documents up. Even now I've got another one up. It's a jurisdiction document that I did about the bankruptcy of 33 and how people bonded into the Department of Human Resources. They issued the certificates, or by there created the straw man, the tax identification number man, all those things that were in The Wizard of Oz. They told people the stories inside these movies. There's been tons of them out there. The point is, this is all voluntary. They're getting your parents to sign these things. The birth certificate itself admits to an adulterous relationship between a man and a maiden, and the informant on those documents, if you go look at the older birth certificates, usually under Section 17 of that certificate, the informant will be the mother with the other name. And if the mother stands up to try to claim, well, that was me down there, I'm the informant, that's the name, that's the married name, I'm carrying the man's last name right there, but up here, that was my maiden name, excuse me. It may be manipulative, but we're not the ones that are supposed to be ignorant. Okay, we're supposed to be smart. We're supposed. It doesn't matter. Your parents have a say. Your parents had the say till you came to the age of reason. Ray, you know who Avi is. Okay, I've already talked to Avi about this concept, especially from the Hebrew mindset. The Hebrew mindset was this. If you gave your word, if it was your word, whether you signed it or in ignorance or whatever, if you gave your word, you had to do it. Now, unless things are going on here that we might consider shocking to the conscience of the universe again or whatever, but those come back under what's called tort. And if you don't come out of it peacefully, just like Jeroboam and the 10 tribes did, then there's going to be look, there's enough war going on, period. There's enough. It's enough of it. But that gets into another issue that I was going to get into when we first started this. And the start of this was, people said, well, I don't have the funds. Well, what are people going to do? People need to learn that even this thing about being someone else's employment is another system of bondage and slavery. The people who do these kind of things are business owners. The whole reason for setting up your own state, number one, apart from having the political rights to actually bargain for your right, is to do business and commerce. The reason that they formed the United States of America was they were trying to protect their assets. You come back and you do treaties and agreements and you do commerce. How did Solomon and David and all the rest of these kings of Israel do it?
Okay, the point is, you have to make a living somehow. And right now,
You're not getting my point. Why are you going to keep making a living instead of designing a life? It's time to be in business and take control of things.